Alex here with part 184 of the My Docket series on child custody and visitation. As my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We go into a couple of oppositions that were filed by my ex's attorney. My usual rule is to break oppositions apart into separate videos. It's one of those what I call main documents. It's not ancillary usually. In this case, both of these oppositions are very short, and in fact are followed by my ex's attorney's motion to withdraw as attorney of record. My ex's attorney is at this point wanting to withdraw from the case. They don't want to represent her anymore. And so for that reason, the oppositions that they file are very short because they just haven't been able to get a hold of her. And they're, for the most part, clones of each other. I think they are verbatim clones where they just say something like, hey, we can't talk to her. We don't know what to do. The motion to withdraw also is a pretty short document that just says that they're not getting along or that she's not paying or something like that. We're going to get into the details very soon. But my mindset, obviously, upon getting these was very happy because that meant this was going to be a whole lot easier. I still had some reservations because this judge was making mistakes in certain areas. So once I saw that she was going to make some mistakes, I always had this idea over my head that she could make other mistakes. Now, in this particular situation, she doesn't make a mistake, but she has a couple more coming up in the case. So, I mean, it's going to be a little bit of a rocky case going forward, despite the fact that my ex's attorneys are withdrawing. But I think really this is going to be one of those videos where we just go straight into what my ex's attorneys have filed. Here we have the motion to withdraw. This is going to start off with the standard introductory paragraph. The attorneys are indicating that they no longer wish to represent my ex because she has, quote, failed to communicate with them, which has inhibited their ability to appropriately represent her, unquote. It did surprise me to see this. And I'm surprised they didn't use the money excuse. Usually they'll say something like she's not paying. They'll usually an attorney who has issues with their client usually will also have the issue that they're not getting enough money. So this is a curious situation because they're not actually using the money excuse. They're using the lack of communication, which reflects poorly on their client. I think a lot of attorneys who have multiple issues with their client will just cite the money issue because it's the least damaging to their client. It's like, hey, they're all right, they just are too poor. So for these attorneys to use this reason it definitely stands out to me. I assumed that they used the money excuse, I just couldn't remember. Anyway, Local Rule 23 provides that a lawyer can be changed at any time before judgment upon the written consent of the attorney and client, or when no attorney has been retained to replace the attorney withdrawing upon motion and notice by the attorney or client. So I've talked about this before. You want to learn more about this, watch the video removing an attorney. But because they are not swapping from one attorney to another attorney, they have to get the court's approval to do this. And so that's what they're trying to do. They're asking the judge to approve their request to withdraw. If she had another attorney like I did when I swapped out my first attorney for my second, then they wouldn't have to ask the court for permission. They could just substitute the attorneys out, and just like that, everything would be fine. According to the rules of professional conduct, specifically 1.16, an attorney can withdraw from representing a client under the following circumstances. So number one, the client fails to fulfill an obligation to pay. Wait, this doesn't say money. Fulfill an obligation to the lawyer regarding the lawyer's services and has been unable to give reasonable warning to the lawyer. Oh no, they have been given reasonable warning from the lawyer. Okay. The other is the representation will result in unreasonable financial. Okay, so yeah, it seems like the money burden is tied in here. And then there's other good cause for withdrawal. Since retaining the law firm, my ex is not communicated with. What? At all? At all? I'd be surprised. I mean, I imagine that the communications broke down, but the fact that they haven't been able to communicate with her at all is very strange to me. The failure precludes counsel from being able to adequately fulfill the obligation to represent her. So, okay, they do mention the money thing in here as under number bullet point 2 and presumably bullet point 1, but they're stating that she just won't talk to them. Well, this does surprise me. I would have imagined that she would have been talking to them for a while and then she suddenly would have stopped. Interesting. Okay. Conclusion. Based upon the foregoing, the attorney respectfully requests the court enter an order allowing them to withdraw. Okay. 239B, which is pretty standard. They're just saying that there's no social security number in this document. Certificate of service under Rule 5 indicating that this document has been mailed to both me and my ex. Notice opposition. The motion opposition notice. This indicates that my ex did not have to pay a filing fee to file this document. We got an exhibit. We got a declaration. Exhibit 1. Declaration. Okay, so it's generic. He's just saying he read the attached motion and that all the facts asserted in the motion are true and correct. So he's taking all of the facts alleged in that motion and he's swearing under penalty of perjury that they are true. This is important that he includes this. This is required under the local rules. Opposition to Omnibus motion to establish continuing duty to disclose. Okay, so this is what I mentioned earlier. It's not really an opposition. They're just going to say something like they haven't been able to talk to her. And I'm going to talk about this a whole lot more when I file my reply. And trust me, it will be a juicy reply and a juicy court order that follows as well. But for now, we're at the opposition and we're just going to go through this briefly. So they're stating here that they, in standard introductory paragraph, that my ex is appearing through and by her attorneys because they haven't gotten approval to withdraw yet. And that she is opposing my omnibus motion to establish a continuing duty to disclose. Papers made upon the following points and authorities. Procedural history. They're discussing the fact that we held a hearing on June 29th, 2015, that they resolved a number of issues. Discussion. Within 10 days of being served by the underlying motion, they have to file an opposition, which is true, according to Rule 13. If they fail to file an opposition, that it can be construed as an admission that what I'm asking for is meritorious and that they are consenting to it being granted. They have not been able to communicate with her despite repeated attempts to do so. As such, they are filing a motion to withdraw and they are still filing an opposition to preserve her rights, so they say. This isn't going to work. And it's going to be very entertaining, I think, to you guys as to how this isn't going to work. But I don't want to get ahead of myself. We're going to talk about this when we get to my reply and then when we get to the court's order. Conclusion. That's it. Based upon the foregoing, it's requested that the court not presume that she admits that my motion is meritorious. They want a hearing. It's lovely how attorneys can do something like this, but non-attorneys can't. Citing the same affirmation statute indicating there's no social security number. Got Rule 5 certificate of service indicating this document was mailed to both of us. We got motion opposition notice indicating they did not have to pay a filing fee to file this. Next document. Another opposition. This is the opposition to motion for order to show cause. They don't want her to be held in contempt of court. I'm going to glaze through this quickly. If I see anything new, I'll stop and read it. But guys, I have a feeling that this is a clone of the previous opposition. As with my previous videos in my Docket series, you can always go down into the description below, click on the link, download the document for yourself, take a look. And if you see something that jumps out at you, you can always mention down in the comments below. Let's take a look here. Nope, it's the same thing. It's a clone. So it's the exact same basis to file the opposition. Exact same certificate of service, exact same motion opposition notice. Here we have a declaration of Chris Hasler. This is my neighbor at the time. Oh, I forgot to mention this. So we were like gone for a while, like on a vacation or something. I can't remember the details. And my neighbor apparently saw somebody snooping in our windows. He saw her peeking through our windows. So he approached her and he was like, hey, can I help you? You know, why are you peeking in my neighbor's windows? And she said, no, I don't need anything. And she just like left. Anyway, when we got back, he told us what happened and he described who it was. And I was like, yep, that's my ex peeking in our windows. So I was like, you know, would you mind doing a declaration? And I'm not going to do anything with it right now. I'm just going to file the declaration, just kind of let her attorney know that this is going on. And if I need to use it in a motion, then I'll cite the declaration and I'll use it as a basis for relief. But for now, I just want it to be on the record, just, let her know and her attorney know that not only do I know what you're doing when we're not around, but there's a third party witness who has witnessed you doing it. You can look through this if you'd like to, but he, by the way, he no longer lives here as of years and years, so I'm not worried about this getting out. This is all old information, not just for me, but also for my neighbor. Everyone has long since moved. It's indicating the address that he was at. It's indicating that we were acquaintances. It's indicating that we shared a unit. It's indicating that, let's see if there's anything. Oh, it's indicating that his daughter attends the same school as our child, or used to. None of us go to the school anymore. It's an old school that we went to. Our children went to. October 10th, outside the dwelling unit, noticed a female approaching our home. Aware that we were out of town, so he continued to observe her. After some observation, he became aware that she was, on again for Rar, the natural mother of our child, that his confidence of her identity is based upon him having seen her with the child at the school. Okay, I forgot about that. So he really was able to identify her. That he approached her after it became apparent she was behaving suspiciously, and he asked her if she needed help. She declined the offer of assistance, and his response was to persist, asking if she was looking for somebody, at which point she left. On December 6th, he was visiting with me and recalled the events of October 10. Wow. Talk about recollection from months later. Anyway, he prepared the affidavit, signed it, and I filed it with the court system. Certificate of service under Rule 5 indicating that I mailed this document to my ex's attorney. And that's that. Non-opposition to motion to withdraw as counsel of record. So here I am filing a non-opposition to let the court know that I have no problem with my ex's attorneys withdrawing from the case. If you want to learn more about what this is, please watch my video on the topic, non-oppositions. Rule 5 certificate of service indicating this document was mailed to my ex's attorney. And that's that. Going into the aftermath, I filed, it looks like 2 documents there. Yeah, 2 documents. Those were both free filings, so I incurred $0 in costs. My ex's attorney filed 3 documents. Those were all free filings as well, so they incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably had to put a little bit of work into that motion in both oppositions, even though they were short. I'm sure it would have been less than an hour, and then he would have had to review the affidavit and the non-opposition. Again, those were also very quick documents. I wouldn't be surprised if he finished everything here in a half hour, considering how short all of it was. And at the rate of $250 an hour, that's going to come to $125 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.